Well, welcome to another edition of the Debt Matters podcast, where we help Canadians find solutions to their debt with licensed insolvency trustees from across Canada. Now, I'm Wayne Kay, and in today's show, we're going to be talking about small business bankruptcies and what to do if your employer lays you off. To teach us about this, I've got my guest today, Daniel Maksymchak from LC Taylor Licensed Insolvency Trustee in Winnipeg, Manitoba. Daniel, welcome back. How are you?
Hi, Wayne. I'm great. Thanks. Thanks for having me back. How are you?
Yeah, doing terrific. This is a big topic where I think a lot of small businesses in Canada are in financial trouble because of what happened with the pandemic. And we're probably going to see, I don't know, what do you think? Small businesses are going to be closing in record rates? Not to be dire, but...
Yeah, unfortunately, I'd say that's quite likely. It depends on what kind of supports will continue going forward here and how fast the economy recovers and people feel comfortable going into stores and restaurants to their normal amounts again. Mm-hmm. But yeah, I mean, it's been a tough coming on 2 years now that these businesses have had to go through, and I'm sure that had a strain on the finances of a lot of them.
I was talking with one restaurant owner, and he did have some of his employees ended up with COVID, so he had to close for, I think, 3 weeks or something. And he said it cost him $80,000 to be closed, and that was still with half capacity or maybe even less. That's a lot of money that businesses have been losing. Are there warning signs that an employer might be in financial difficulty that we as workers can keep an eye on?
There are. And if you're knowing what to look for, it can be helpful to protect yourself and watch out for the worst impacts of that. And of course, the warning signs that are visible to you are going to largely depend on the role that you're in the company. Of course, if you're in the finance or accounting department, you're probably going to have a much different perspective and more obvious perspective of things than someone in sales or a server or something like that, right? So some of the warning signs that you could see if you don't have much visibility of the actual finances of the company would be stuff in your day-to-day job that are changing and perhaps reflecting, a decreased cash flow or a decreased ability to fund things on the part of the business. So if you notice that, stocks are dwindling, the company's not keeping as much inventory, perhaps, it's because there's not the cash there to buy the inventory and the shelves are emptying because of that. Or if you deal with suppliers who are maybe complaining or mentioning offhand that they're not getting paid as quickly, it may be a sign that, the business doesn't have the money to pay them. Caretaking, maintenance, that sort of thing falling behind can be as a sign of, cash flow issues, as well as, the most obvious one and the one that's going to impact you personally would be if your employer wasn't able to pay your payroll on time or ask you to defer it for a period of time or something like that. Of course, that's where the risk to you becomes more apparent because, the nature of the job is you're providing your services or your labor in exchange for money. And you want to make sure that the money is going to be received when it comes due.
Any advice on what to do if that situation occurs where they say, okay, just I have the money this week, but I'll pay you next week?
Well, I mean, you have to, it's a bit of a balancing act because you want to make sure that the company survives for the long term, hopefully, so that you do have that employment for the long term, but you don't want to, if it's a lost cause, you don't want to do it at your own expense. So if you're asked to defer your wages or something like that, or the payroll is not made, definitely speak up and find out why and make sure that you get a satisfactory answer for that and that you're confident that, the things are going to be able to be turned around and ensure your continued employment if you do agree to that. Mm-hmm. Otherwise, you're risking by deferring things, you're risking that you may never get paid for it, right? Mm-hmm. If a bankruptcy or a receivership did occur, then that definitely reduces your likelihood of getting paid what you're owed, at least in full.
So I guess we've started talking about the employee and trying to watch what's going on with the business that might be having financial trouble. But now let's kind of switch over to the employer that is in trouble. They know their business is having a tough time. And you mentioned bankruptcy and receivership. Are they the same? What's the difference?
No. So they're often, thought of the same, but they are different legal processes. Sometimes they do occur concurrently, but they are as I said, separate legal processes. So what a receivership is, that's done by a secured creditor. So a creditor that has collateral on one or more significant assets of the business to essentially realize on that collateral, or, get the best return on that collateral so that they can get paid as much as possible of what they're owed. So a receivership can be that secured creditor taking control of the business or taking control of certain assets of the business. And it may be such that those assets are substantial enough that the business can't continue anymore. So effectively it causes the business to shut down. Whereas a bankruptcy is the business shutting down, right? So usually it's the case that the company isn't viable and that the company has assets, and the unsecured creditors, so the creditors of that business with no specific assets as collateral, but are owed money. The bankruptcy, what it does is it allows for the orderly distribution of the assets of the company to those unsecured creditors in accordance with the government priorities and how they're laid out. So they are different processes, but I mean, if you're an employer, if you're the business owner, essentially they're very similar, and that your business is often done. And if you're an employee from the same end, it's your job is often done, right? So legally they're different processes, but depending on your relationship and your involvement with that company, there may not be much practical difference from your perspective.
Okay. Now, what about this bankruptcy that I hear about where they then restructure the company? Is that a different entity on its own? So then those are further proceedings. It could be what's known as a Division 1 proposal, which is a proposals made to your creditors to, rather than liquidate the business, to essentially restructure the debt and get it to a manageable amount or manageable repayment terms where the business can continue to function. Or there's, for larger companies, there's something called the CCAA, Companies Creditors Arrangement Act, that does the same thing. It's a court monitored process where the company can try to restructure itself, sell its restructuring plan to its creditors and get approval so that it can rearrange itself and continue to function as a viable entity, ideally. Mm-hmm. Okay. I was downtown talking with somebody and we were mentioning, or they mentioned to me that, this barber next door was doing great, but now they're having a real tough time and they're looking at moving because of this, and they're looking at declaring bankruptcy because they have a couple of big debts that they want to get rid of. And I mentioned, we got this podcast and I talked with all these great experts who can help out business owners. Does a business owner's bankruptcy, is that different than a business bankruptcy? Or are they the same?
It depends. So it's going to come down to if the business is incorporated or not, largely. So an incorporated entity is a separate legal entity from its owners. So if this barber is an incorporated business doing the barbershop operation, then that business theoretically could go bankrupt without the barber himself going bankrupt personally and affecting his personal assets, right? But if the barber's just a sole proprietor, he didn't incorporate, and he's cutting hair and operating his business under his own name, then there's no legal distinction between his barbershop business and him personally, which means that in a bankruptcy, not only would the business assets and those assets of the barbershop come into play, but also his personal assets would as well, right? Perhaps his house or investments he had or anything that he had personally, not necessarily related to the business.
Mm-hmm. Good to know. So when we look at this kind of a situation, is consumer proposal available for businesses, or is it called something different?
Consumer proposals are available to sole proprietors, so individuals, as long as they meet the other criteria of the consumer proposals. If it's a corporation, then it's a different sort of proposal called the Division 1 proposal in the Bankruptcy and Insolvency Act, and it can be similar. It's just done by a corporation, and it would be the corporation theoretically making payments out of its future income to settle the payments of the debts of the past. Yeah.
I love how I can just throw these things at you and you're actually remembering all the different names of these different parts of the government and legislation. That's amazing. So When it comes to bankruptcies, let's talk about business owners. They're having a tough time, and all of a sudden they're just not getting the income to settle their debts. At what point do you appreciate them contacting you?
The sooner the better, to be honest. The sooner things are in the process, the earlier things are. There's more options available, right? Sometimes things get too far along, and by that time, maybe the Canada Revenue Agency has already liened certain assets, or certain creditors may have already repossessed assets, and then there's less to work with from the perspective of a restructuring, right? Because there's less assets available to deal with in that situation, and to look at selling off parts of the business to save those parts that are still viable and whatnot. So if you want to retain control as a business owner, you're best to speak with the licensed insolvency trustee as soon as possible, so that you can have the full suite of options available to you, as opposed to having the creditors kind of drive the bus and have already done, kind of hived off the valuable parts of the business. And, then there's less viable tools in the toolbox of the trustee to perhaps save that business.
And I think this is one of the main things we want people to learn with the Debt Matters podcast, is that they can reach out to a licensed insolvency trustee and get free advice on that first contact. And often that is enough to give them a little roadmap of where they can go and how they can maybe weather the storm.
Yeah, absolutely. And as you say, most trustees, certainly us here at LC Taylor, offer free consultations for these business owners or anyone else who's interested in knowing what his or her options are, and making sure that they are fully informed when they're deciding how to respond to perhaps inquiries from their lender or different creditors. Of course, badgering them for payment. It's good to know what your options are before you go into things that you can't turn around from.
Mm-hmm. And if my employer declares bankruptcy or is in receivership, is there anything that I can do regarding my job in that situation, or do we just continue as normal?
Well, if it's a bankruptcy or a receivership, in most cases, the job is essentially terminated. So sometimes the receiver or the bankruptcy trustee, depending on the role of the employee, may enter an agreement with that employee to continue offering services after the bankruptcy, so as to assist the trustee and provide better outcomes for the creditors. But in most cases, that employee is going to effectively be terminated as a result of the bankruptcy or the receivership. And once that termination is in effect, it's the same as any other termination from a job legally. You're still entitled to termination pay. Any vacation pay that you might be owed is now owed, is payable. But the problem is that if the company is bankrupt or in receivership, it's one thing to be legally owed this money, and it's another thing, unfortunately, to be able to collect on that money.
Mm-hmm. So can you recover that money? How does that work?
So there are protections in the Bankruptcy and Insolvency Act for employees who are unfortunately put in this situation, but they haven't really kept up with inflation, at least in recent years. It's capped at $2,000 of an amount that an employee is owed is considered to be preferred, and it would rank ahead of many of the other claims in the bankruptcy. So there's a good chance that would be paid out. You'd get your first $2,000 that you're owed. But after that, any remaining amount that you're owed is just a regular unsecured claim in the bankruptcy, along with, maybe the business's credit cards, or its, janitorial contract, any other thing like that is owed by the business. You would rank in there, and you would receive your prorated share of that money, which, in a bankruptcy or receivership is usually pennies on the dollar for an unsecured creditor like that.
Right. Okay. And who knows how long that would even take?
Yeah, and that's the other part too, right? I mean, it's not only are you taking a large loss likely on the amount that you're owed, but you're also not going to be getting it anytime soon. So it's not going to help you pay the bills and put food on the table in the meantime.
Right. I hope that most of the employers that are going through this painful bankruptcies, and I hope they do have the money set aside for their employees, who often help them with the business.
Yeah, and that's, usually we do see that they try and make sure the employees are taken care of, at least for current wages. But when the bankruptcy is filed, that also triggers some other monies that the employees are owed, right? For termination pay. Now they've got to go and find another job. Whereas if they were laid off in the normal course, they would, either have gotten notice to allow them to go and find another job, or they would have been paid in lieu of notice to get them through that period where they're looking for another job. Mm-hmm. And in the bankruptcy, they don't have that ability. So without that termination pay, it really becomes an issue for these employees to survive in the meantime until they find another job. And the employers, they pay your current wages many times for what you've earned up to the date of bankruptcy, but sometimes they don't realize, or they simply don't have the funds to make good on that termination amount that's owed.
You can still get employment insurance through this,
yeah,
right?
So you would qualify for EI. It would count as a regular termination for that. And there is another program. It's called the Wage Earner Protection Program, which was set up essentially to assist employees in this exact situation who are owed money by a business that's in bankruptcy or receivership, but by virtue of the fact that they're in bankruptcy or receivership, don't have the money to pay this amount that's owed. Mm-hmm. So what essentially happens is the government will pay the claim on behalf of the business, and then the claim of the employee for whatever amount is owed then becomes the claim of the government. So instead of the business owing you an amount for your termination pay, let's say, the business owes the government, and the government gives you that termination pay out of public funds. Oh. And that's it's a very good program. It helps out in these situations, and it is often more timely than receiving the money through the normal course. But there are some drawbacks in that it is capped. So it's capped equal to 7 weeks of the maximum EI amount payable, which currently is about $7,500. So if you're owed more than that, you wouldn't receive the excess through that program. Mm-hmm. And as well, it only applies in cases where the company has formally declared bankruptcy or receivership or entered into another sort of restructuring. If the business just simply shuts the doors and ceases to operate, it doesn't trigger that legal proceeding of bankruptcy or receivership, which brings this legislation into play.
Oh, very good information. I did have one question as you were talking about that. Can a person who is seeing their business now becoming bankrupt, is it okay for the employee to reach out to an LIT?
Sure. Yeah, there's no harm in that. And I mean, we wouldn't charge for that. You could explain your situation as to what you're perhaps experiencing with your business. And, we could certainly try to offer advice into how to protect yourself and what's available to you as an employee going forward. But it would be the responsibility of the trustee of the bankrupt business that has to reach out to the employees and arrange for this WEPA. It is a requirement under the law that the trustee or receiver, prepares the necessary paperwork, files the necessary claims with the government. And as long as the employee does their part, then the government will transfer that funding to the employee.
Terrific. Well, that's good to know. So it's going to happen one way or another. Somebody will be in contact with them. This has been great information. Anything else you need to add to today's topic, Daniel?
No, I think that's a good description. I'll just add again, as you've mentioned, if you're either an employer or an employee in this situation, be it from COVID or any other kind of circumstance, don't hesitate to reach out to a licensed insolvency trustee in your area to discuss what options are available to you, either as the employer or as the employee, to try and limit the damage, so to speak. I know that employers want to look after their employees and, of course, try to save what they can of their business. And the employees, want to ensure that they can continue to put food on the table for their families. And there's no harm in reaching out to an LIT to try to, make that happen as best as is possible, given the circumstances.
Terrific. All right. Well, Daniel, thank you very much for all the information. And if somebody wants to reach out to you or the team at LC Taylor, they can go to the website, lctaylor.com. And that's it for today's Debt Matters podcast. We do ask that you subscribe wherever you do get your favorite podcast from. And of course, if you want more information, you can always check out our website, debtmatters.ca.